This conference will now be recorded.
If you need to rewatch it, you'll find it on my YouTube channel, and you can obviously rewatch it as many times as you wish. Ask any questions as we go through. There is a chat button which some of you have found already, which you can ask questions through if you need to. If you want to, and you're feeling a little bit more positive and proactive, you can unmute yourselves and you can ask questions that way, which I encourage you to do so, because again, talking to me for 45 minutes may bore you a little bit rigid in that particular sense. Okay, in terms of just a very quick overview, it's the reason why it's so complex, and I say this for lots of bits of legislation that we go into, is that when they create legislation, they write it in such a way that it takes numerous court cases to decide what they have meant by the legislation. And as you know, over the last 15 years, there have been numerous court decisions that have been made regarding the interpretation of deposit legislation. And as you may be aware, and for anyone that did watch the 5 hours on Tuesday regarding the court case and the signing of prescribed information, it just shows you the arguments that solicitors will use in relation to whether something was valid or not. So as much as I love to say I love test cases, I don't want you to be a test case, because it's a very expensive way of proving whether you were right or wrong. So my position has always been try to minimize your risk as much as you can. For those that have been on my courses before, you will probably know that I say about deposits that I would, if I was a letting agent, and I know this is very easy for me to say, I would never take a deposit. Because even if what I'm saying today is correct, we may have a court decision at a later stage which may overturn our understanding of legislation. So there's always that danger. And for those that have been on my courses, you might remember me referring to Superstrike. And Superstrike was one of those situations where a decision was made at court level which basically overturned how many people were understanding legislation to be interpreted. Even the government were interpreting it in such a way, and the court said, no, that's not the correct way of interpreting it. This is the correct way. And that caused lots of people lots of problems. So therefore, my position has always been, how can I reduce risk to me as a landlord or letting agent? And one of the ways of doing that in relation to deposits is by not taking them at all. Now, I fully appreciate that is probably not going to be something that you guys as letting agents who are mainly on this course can do. But for me, that would be something I would certainly consider doing, or looking at ways of mitigating that risk. And as you can see on the right-hand side of this particular screen, I'm not a great fan of them personally, because they charge a fee. I'm not too sure what the benefit.
It keeps falling off all the time. So I can sell it.
Let me just put those people on mute. Whoops, there's some background noise. We've had a stranger turn up. But in terms of zero deposits, I know some of you may use. I don't know if anyone uses zero deposits or how they found zero deposits, but I fully accept that zero deposits has its benefits to a landlord or a letting agent. I'm not too sure how many benefits there are for a tenant. If I was a tenant, I personally wouldn't want to be using zero deposits, but I fully accept there is a benefit to a landlord of using, or a letting agent of using zero deposits. I think Anya said there, yeah, it does cover a lot more than the 4 or 5 weeks, which or the 5 or 6 weeks that you may only get with a monetary deposit. But there are a lot less hoops to jump through in terms of the landlord. It's not going to stop Section 21. There aren't compensation claims. So from a landlord or letting agent perspective, then zero deposits is actually quite a beneficial scheme to use. I don't know how good they are at paying out. I fully accept I've not gone through it personally. I'd be interested to hear if anyone's had any experience of zero deposits and how quickly or how unquickly, if that's the right way of saying it, they pay out. Now, I had a conversation with a client quite a long time ago when he was first approached by zero deposits, and he said to me in secret, if that's the right way of saying it, he did say that the person that was selling zero deposits to them did say there is a figure which zero deposits would not pursue the tenant for. So basically, zero deposits pay out if you have a substantiated claim, and then in theory they chase the tenant for the amounts that they've paid on their behalf. Now, from that perspective, I think they said to my client that if the tenant owed £600, for example, and they had paid, and Zero Deposits had paid you as the landlord or letting agent £600, they probably wouldn't chase the tenant through court for it. They might write to the tenant and say, by the way, we've paid out £600 on your behalf, you owe it to us. But if the tenant refused to pay, then my understanding is that they wouldn't pursue it through court. And from my experiences of court, unless it's a substantial amount of money, in most cases, it's not worth pursuing. So from that experience, Zero Deposits is not that potentially is not that beneficial to a tenant. But from my own perspective, legislation, so we have the Housing Act 2004, which covers deposit protection. We also have the Prescribed Information Order 2007, which we're talking about in a bit more detail later on. And as I said to you before, we have numerous court cases, probably in the hundreds, which cover deposit protection and the interpretation of deposit protection. But what I want to do today is just to really give you a very quick overview of the things that I think most agents potentially, and landlords in particular, are potentially doing wrong, and what you need to do as a business to protect yourself, because that's what it's about. It's about trying to protect yourself to the best of your ability. However, just take into account my first comment, the best way of protecting yourselves in relation to deposit protection is by not taking a physical monetary deposit. How you achieve that is entirely up to you, but that's what I would do if I was starting from scratch. But I fully accept it's very easy for me to say that not working in lettings in relation to day-to-day management. So that's why it's complex. Court cases, the knowledge is poor. I fully accept some people on this course have always said to me they find deposit protection quite easy, but from my own perspective, that may be the case for the more knowledgeable people on this course. But lots of landlords in particular, self-managing landlords, have no idea how deposit protection works. They have an understanding themselves how it works, but that has no bearance in relation to what actually the legislation requires. So when I deal with self-managing landlords, it's incredible the amount of knowledge that is missing in relation to deposit protection. And we go through some of the issues that they may face. I've got my little laser button, as you can see there. So it's just really to whoops, let me just, shouldn't have done that. Okay, so hopefully, okay, so the legislation, just to run it through in terms of what you need to do from receipt of the money. So as you know, and I'll put my little laser pen up there so you can see it. So the important thing to remember in terms of deposit protection is that you only have 30 days to comply from receipt of the money, which I know most of you will be very aware of. So it's not from the start of the tenancy, it's from when you receive the money. And for those that do student lets, again, if you're receiving it 9 months before the start of the tenancy, then the start point is when you receive the money, not when the tenancy starts. The other thing which I sometimes trips people up is part payments, especially with students, where they pay you, each student pays you at a different time scale, so a date, shall I say. So again, very clearly, it's from receipt. So if you receive money from one joint tenant and then 60 days later you receive money from another joint tenant, the 30 days started when you received the money from the original tenant. So you would have to almost part protect it, if that's the way of saying it, and then protect it in its whole when you receive the other part payment from the other joint tenant. So my advice would be is that if they're going to pay you in bits and pieces, just say to them, look, as a group, wait until you received all the money together and then pay me as one group. What I don't want you to do is pay me in bits, because that's potentially where a landlord or letting agent would fall foul of the legislation, because then you've got to work out when did I receive the first payment, etc., etc., etc. And it's not that easy. I wouldn't say it's not that easy, but you can. I know you can top up in relation to the DPS. I think my deposits and TDS are the same. But from my own perspective, the easiest way for you to deal with it as a landlord or letting agent is to receive the whole deposit in one payment rather than in part payments. So again, I know that's more likely with student lets, but that would obviously be, from my perspective, something that I would do or advise you to do. William just says students do this a lot, even though, sorry, William, I'm just trying to read your message. Students do this a lot, sadly, even though I ask them to pay in whole, we protect in part and send them subscribed information within 30 days. Yeah, I mean, I would probably say, William, the way I would potentially do it is just nominate one person to deal with the deposit. So they collect it on behalf of everyone else, and then you say, look, this is the lead tenant. because I think you would probably nominate a lead tenant for the purposes of a joint tenancy, and that's the person we would expect to make the deposit payment when they've received it in its entirety. Which again, I fully appreciate they might completely ignore and still pay you in parts, but that's the way I would do it, because I've seen a couple of letting agents and landlords who have done that, as in taken part payments, and then they've just not protected it until the end of the until they've received the whole amount. And when they do that, then as I said, you've potentially got compliance issues in terms of the penalty and potentially Section 21. But obviously with students, it's less likely that you're going to serve Section 21 upon them. The next part, which is underneath here, is comply with the initial scheme rules. And for me, that's a really important, that's a really important part of what we're going to be discussing today, because lots of landlords don't understand what we mean by the initial scheme rules. And I will try and interpret it or define both of them for you. If there was just a question there, let me just go to. Oh yeah, William's talking about a relevant person, which we'll talk about very shortly. So you comply with the initial scheme rules, and I'll bring up the initial scheme rules for each of the schemes, because I just want to make sure that you understand what we talk about when we refer to the initial scheme rules, because the initial scheme rules are the rules that you must follow under the Housing Act 2004. That's where the penalty applies. So there's a difference between initial scheme rules and scheme rules. So I fully appreciate we're getting into a one-word difference, but that is the legislation. It's quite complex in that scenario. So there are two different types of scheme rules. There are initial scheme rules, which fall under the Housing Act 2004, and that's where the penalty applies. And then we have scheme rules, which only apply to the scheme, and there is no financial penalty for that under the Housing Act 2004. If you don't follow scheme rules, potentially the schemes may, for example, not adjudicate. So there's no financial penalty in terms of the Housing Act, but if you don't follow a scheme rule, the schemes may impose their own penalty, which likely could be we aren't going to offer you free adjudication because you haven't followed the scheme rules. And hopefully that makes a bit more sense as we go through today's training course. As I said, deposit protection is not a simple process. I think someone in Downing Street or Parliament, probably after one of their parties, just decided they wanted to get back at letting agents and landlords, and that's what they've done. They've really created a whole pyramid of ambiguity. Don't forget, this was actually under the Labour government, so I don't want to blame the Tories on this one. This is actually a Labour government piece of legislation which has been changed numerous times. As you probably know, it was changed in its biggest form under the Deregulation Act 2015, when they changed all those things in relation to Section 21s as well. So we've had lots of changes to the legislation, and it's still quite complex, and it's still probably the biggest defence in relation to Section 21s. Why is the Section 21 not valid? Well, it's not valid because the agent or landlord have not complied with the legislation correctly. So there was a question there from Jacqueline. Jacqueline, if it's a real complex question, I might leave it to the end. How do I go about collecting payments from tenants and guarantors if the deposit claim exceeds deposit held? I have a student group. Yeah, actually, Abby's got, there's a question underneath Abby's, So what you would do, Jackie, which is what I think Abby's saying, is that you would basically bypass deposit adjudication. So if the tenant is refusing or not agreeing to the deposit claim, then you would basically take all the tenants and the guarantors to small claims and go for the whole amount. The thing that you need to remember is that if you do get a judgment for that, then you need to make sure that the court order instructs the deposit schemes to release the money back to you as the landlord if the judge finds in your favour, if that makes sense. So you don't go through deposit adjudication if the tenants are disagreeing. The best thing to do is go to small claims and go for the whole amount. If the judge finds in your favour, then you just make sure that the court order states that the DPS, my deposits, whoever it's going to be, has to release the deposit in full to you as the landlord. Hopefully that's answered your question, Jacqueline. I don't know if that has or not, but basically Abby's right in her very succinct answer back to you. You go to small claims. So that's the initial scheme rules, and we'll talk about that in a bit more detail very shortly. The other thing to remember, so in addition to the Housing Act 2004 and following the scheme rules, you then have an obligation to provide prescribed information. Now that again confuses people, especially landlords, regarding what they need to provide. And again, we'll go into a bit more detail about that on a later slide. But the important things to remember from my own perspective is the word prescribed means the information is prescribed, not how the form looks. It's the information which is important. So for those that use my version of a tenancy agreement, you'll find the prescribed information in section 8 of the tenancy agreement. Now, why I include it in the tenancy agreement is very simple, is that the tenant will sign the tenancy agreement to say that they've received the prescribed information. So that's why I include it in section 8, because in a sense, about 85% of the information is already contained within the tenancy. So why would you want to repeat it? So in my agreement, we just say, please refer to clause 1.1, please refer to clause 1.2, because most of the information required under prescribed information is actually contained within the tenancy. The only thing that's not contained within the tenancy is the scheme leaflet. So in addition to my tenancy agreement, whoever's using my version of the tenancy agreement, in addition to that, would have to provide a copy of the scheme leaflet, which again, we're talking about on a different slide, because again, that's really important in relation to compliance. So the legislation, as I said, can be found in the Housing Act 2004. For those that are really sad like me, you'll find that in sections 213 to 215 of the Housing Act 2004. And then it's the Prescribed Information Order 2007, which talks about what you're obligated to give in relation to prescribed information. As I said, it's the information that is prescribed, not the way it looks. And just to make you aware also, in addition to that, the schemes do not, and I emphasize the word do not, especially for landlords, do not provide the prescribed information on your behalf. You as the landlord or letting agent have to provide that. Now they provide templates, as you'll see later on, but they don't provide the prescribed information. They might give you a template for you to fill out as the landlord or letting agent, but they don't physically fill it out for you. And you'll see that on a later slide. So just to make that absolutely crystal clear, because some landlords will go, yeah, but they've served the prescribed information on my behalf as the landlord. They don't do that for you. Trust me, they don't. What they do is they provide you a template that you then have to fill out as the landlord or letting agent. But as I said, if you're using my agreements or my old employers' agreements, being TFP, we have in our agreements the prescribed information already contained within there, so you don't need to provide it again because it's already contained within the tenancy. The only thing that you need to give in addition to that, as I say, and I will reiterate that, is a copy of the scheme leaflet, because obviously I don't have up-to-date versions of them, so that's something you would need to download off the website yourselves each and every time you issue prescribed information. And for those that get my emails, you will see that all the schemes update their leaflets on a reasonably regular basis, maybe once every year. So it's always good just to double check to make sure you are downloading or using the most up-to-date version of the scheme leaflet. Because again, if you give an out-of-date version of the scheme leaflet, it is quite a simple argument to say, well, actually, it's not valid because you've given me a scheme leaflet that's 2 years old or whatever it's going to be. And the schemes aren't that good at telling you that they've updated them, are they? From my experience. So you've almost got to go onto the website each and every time to make sure what they are doing or what you're serving is valid. So I personally would not have a saved copy on my hard drive each and every time that I want to serve the scheme leaflet for a deposit scheme. I would just download it each and every time from the website from their website when I want to serve that scheme leaflet. The financial penalty, just to reiterate it, as you will all know, so the financial penalty is between 1 and 3 times the deposit value. Okay, it's entirely up to the judge depending on the circumstances. My understanding and how judges have awarded compensation thus far, if it's a landlord, they generally go 2 times. If it's an agent, they normally go 3 times. So they give a landlord a little bit more leeway than they would do an agent. I'm not saying they will do that in all cases, but that's generally the position. So 2 times for a landlord and 3 times for a letting agent. As you will be hopefully all aware, it's multiplied each and every time that you were obligated to protect the deposit. So as you might have heard me say on a course, on one of our training courses recently, there was one landlord who ended up with an £85,000 compensation claim against her because she had renewed the tenancy, I think 7 or 8 times over a period. And therefore, each and every time that the tenancy was renewed, the penalty applied, because each and every time that the tenancy was renewed, there was an obligation of the landlord to recomply. Now, this landlord had not protected the deposit at all. So she hadn't even attempted to protect it. She wasn't even aware of deposit protection, just to make you aware of that. So there was no attempt or effort to protect the deposit at all. So therefore, each and every time that the deposit, each and every time that the tenancy was renewed, there was another penalty that applied. As you may all be aware, under the Deregulation Act, which was the biggest change to deposit legislation recently, the government changed the legislation to say, so long as you have protected the deposit in the first place correctly, you're always deemed to have protected it correctly thereafter. So when the tenancy is renewed or goes statutory periodic, so long as you've done it correctly in the first place, each time it's renewed or each time it goes periodic, you are deemed to have complied by default. However, that does not apply, or those protections do not apply, if you haven't protected the deposit in the first place. So in my example of the county court case, she had not protected it at all. So the Deregulation Act did not protect her in any shape or form. So therefore, each and every time that she renewed the tenancy, she was incurring a penalty of up to 3 times the value of the deposit. Hence why she was hit with a compensation claim or award of just over £85,500. The last point on this particular one, under the financials, where it says tenant and any relevant person can commence litigation, and we'll talk about a relevant person in a bit more detail shortly. So the tenant and any person that's funded the deposit on behalf of the tenant can start a compensation award against you. In most cases, that will happen where you've gone to Section 21, you've gone for possession, it transpires that you haven't protected the deposit correctly. The tenant can counterclaim at that point, and the judge can make an award against you financially. So just to make you aware, that's how generally most cases happen. It's where you're trying to evict them, or you're trying to claim a deposit deduction against them. That's where most tenants will realise that you haven't protected the deposit correctly. And as you probably know, and in terms of another penalty, this is the Section 21 restriction. If you don't comply with deposit protection correctly, then potentially your Section 21 or any Section 21 that you serve subsequently may not be valid. So again, if you haven't complied, then potentially with the initial scheme rules, then your Section 21 won't be invalid. You can rectify that. So if you haven't complied with deposit legislation correctly, if you can evidence that you've given the deposit back to the tenant in full, or you can evidence that you've given the deposit back to the tenant less any agreed deductions, then you can serve a valid Section 21. But you must do that first before you serve your Section 21. So if you haven't protected it correctly, and you know you haven't protected it correctly, then if you can evidence that you've given it back to them in full, as the tenant's given the money back to the tenants in full, or less any agreed deductions, then you can serve a valid Section 21. Obviously, the tenant can still then go for you for compensation, but at the very least, it allows you to serve a Section 21 notice. If you haven't given prescribed information, you can give that late. So if you give prescribed information late, so long as it's before your Section 21 is served, then that is a valid Section 21 notice. Again, that does not stop the tenant from seeking compensation against you in terms of a financial penalty. So it allows you to serve Section 21, but just be aware it's very likely that any tenant would then seek compensation from you in relation to the financial penalty. Is that okay? So the financial penalties are quite severe. So that's why it's so important that you understand what you're obligated to do as a landlord or letting agent, because these are the things that come up all the time. I've had a number in the last 6 months. I get lots of people that come to me and say, look, Daryl, a friend of mine's recommended you in just in relation. I've just been given a Section 21 notice. I just need some help defending it. And deposit protection is the first thing that I go to, because I'm reasonably confident that most agents and most letting agents get it wrong. Most letting agents and landlords get it wrong. So therefore, that's the first place that I start. Is this Section 21 valid? Let's have a look. And the same with deposit deductions. So they go to the agents saying that they want to deduct £500 from my deposit. Again, the first place that I look at is deposit protection, because again, most letting agents and landlords do get an element of it wrong. Claire's just asked a question. I didn't see that, Claire, so I've got to look. Is it therefore considered best practice to serve prescribed information with a Section 21? I personally wouldn't, unless you know that you haven't done it correctly, Claire. So if you're 100% certain that you've done it correctly in the first place, then I wouldn't need to serve it again. If you want to serve it again as best practice, and I'm sure some of you may serve everything again, so that's one way of doing it. So if you know that you haven't served it correctly, then what you try and do is you try and bamboozle the tenant without sounding disrespectful to a tenant. So you serve them everything you can think of: gas safety records, EPCs, how to rent guides, deposit protection, Legionellas, risk assess, anything you can think of, just serve to them. But I would also serve that a couple of days before I serve my Section 21 to be safe. Never serve it in the same envelope, for argument's sake, because their argument would be in court, well, I opened the envelope and the first thing that fell out was the Section 21. The next thing that fell out was the prescribed information. So I would never serve it in the same envelope or even on the same day. I would always serve it a couple of days before I serve my Section 21 notice. But as I was saying, and I reiterate, if you know you haven't done it correctly, then just try and serve it with everything else you can potentially serve. As I said, it's less likely they would notice that you haven't done it correctly. So I know lots of you will do that. You will serve all the gas safety records again. You will serve all the how to rent guides again. You will serve the EPC again, deposit protection, EICR. I know an EICR is not is not related to Section 21 compliance, but you can serve that if you want to. It's all about trying to bamboozle the tenant without sounding disrespectful to a tenant. But always serve it a couple of days before, Claire. So that's the financial penalty. In relation to liability, because I just wanted to make, especially the landlords on this, because I know there's a couple of landlords on the course, just to make you aware that, and I always say it on landlord courses, whatever the agent does or doesn't do is as if you are doing it yourself. So the way of looking at it is, I need to make sure that my agent is doing this correctly. And the only way of doing that is by checking their paperwork. So for agents, just to start off with agents, this was a High Court case in 2010. The agent took the deposit but didn't protect it correctly. Their argument is that we didn't need to protect it, or we're not the person liable to pay the penalty. But in this particular court case, which is still relevant today, Draycott's versus Hannells, the person who is responsible is the person who should have protected it. Now, if the agent is collecting the money, then the agent is the person that is liable to protect it. And if they don't protect it correctly, they are liable to the penalty as well as the landlord. However, if the agent disappears off the face of the planet, the landlord is always going to be the person that's held liable. So as a landlord in particular, and this is what I always say to landlords, is you've got to check that your agent is doing it correctly. Because if the agent doesn't do it correctly on your behalf as the landlord, you are the person ultimately who is responsible. Yes, you can chase your agent and say, look, Mr. Agent or Mrs. Agent, you've done it wrong, therefore I want compensation. But ultimately, you as the landlord is the person who would be held liable in court if the tenant wanted to chase you rather than the agent. So that's Draycott's versus Hannells. That very just clearly defined who's liable. It can be the landlord or it could be the agent. But ultimately, it's always going to be the landlord if the agent disappears off the face of the planet. For non-managing landlords, very simply, you've just got to check that your agent is doing it correctly. As I said, whatever the agent does or doesn't do is if you are doing yourself as the landlord. So really important. You can't hide behind the agent situation. Whatever the agent does or doesn't do is if you are doing it yourself. And the one for agents on this course, and the way I just going to reiterate the importance of it, is in relation to let only. So if you are a let only agent, then from my own perspective, you're always going to be held liable if you collect the money. So if you collect the money on behalf of the let-only landlord and you pass the money over to the let-only landlord for the deposit to be protected, if they don't do it as the landlord, you can still be held liable as the agent, because under the law, you should have protected it when you received it. If the landlord protects it in its entirety, then that's fine. You are protected. But if the landlord doesn't do it right and you have collected the money in the first instance, you are the person that can also be sued. So for let-only landlords, you just need to look at how you mitigate that risk. So as you say here, I personally would never pass on the funds to a landlord. I would protect the deposit myself as Mr. Agent. That's one way of doing it. Obviously, the other way of doing it is protecting it yourself and then transferring it internally to the landlord via the DPS. Because I know the DPS do that. You can transfer it internally between accounts. That's fine, because then you know it's protected in its entirety. The other way of doing it, which you see on my screen, is allow the tenant to pay the landlord direct. So if you've got a let-only landlord and the tenant and the landlord wants to protect the money, that's fine. Okay, I will just advise Mr. or Mrs. Tenant to pay the deposit proportion of the monies upfront direct to the landlord. Because you've never received that money, you're not going to be held liable as the let-only agent. But if you receive the money as the let-only agent and they don't protect it as Mr. Landlord or Mrs. Landlord, then you can be held liable for non-protection as well, because that's what the law says. And that was very clearly defined in the top court case here in Greycotts versus Hannells. So for let-only landlords let-only agents out there, just need to consider how you deal with deposit protection. Protect it yourself. That's fine. Keep it, hold it, that as per normal. Which some of you may want to do. Some of you don't want to deal with deposit deductions, etc. at the end of the tenancy, so you don't want to get involved. You can transfer it internally to the landlord via the deposit schemes. You can do it that way. But probably the easiest way for me is not to touch the money at all in relation to the deposit and get the tenant to pay the landlord direct in relation to a let only. They will still pay you the rent, obviously, so you can take your commission. But in relation to the deposit, I would get the tenant to pay the landlord direct. That would be my preferred option, which I know is not always the easiest option, but that's the option that I would take if I was dealing with let only landlords. Sorry, Will, I think you made a comment there. Apologies. William changed our policy a few years ago that all tenant-fine tenancies we do the tenants. Okay, so you doing what I said, William, yeah, which is he gets the tenants to pay the landlords direct. That's the way I would do it. I don't know how easy or difficult that is now, William, but in the day of age of electronic transfers, I'm sure it's relatively simple to pay the landlord direct as the let-only tenant. So that's just in terms of liability, just trying to identify who's liable for what. But ultimately, as I said, in most cases, it's always going to be either the landlord or letting agent, or landlord always by default. So landlords just need to be careful that they're using an agent, that they have evidence that the agent has done it correctly. Relevant person, again, something which lots of agents don't ask. If you don't ask, you're not going to know. That's probably the most easiest way of describing it, because that's what agents always say to on courses. Well, how do we know there's a relevant person? Well, if you don't ask, you're not going to know. So this is the definition under the Housing Act 2004. So I haven't made up this particular slide. This slide is with the wording from the Housing Act 2004, and it says a relevant person means any person who, in accordance with arrangements made with the tenant, pay the deposit on behalf of the tenant. Means any person who, in accordance with arrangements made with the tenant, paid the deposit on behalf of the tenant. Okay, what we don't have is we don't have a court case to say exactly what that means. All I would say is if you ask the question, who is paying the deposit, and the tenant says me, then there is no relevant person. Okay, that would be the very simplistic logic on that. If you don't ask the question, who has paid the deposit, then you always end up with that ambiguity. Is it a relevant person or isn't it? So if I ask the question on the application form, for me, that's the belt and braces way of doing it. Because if it transpires it wasn't the tenant, but the tenant's told you that on the application form, that's your protection. If you don't ask the question on the application form, then potentially you're leaving yourself wide open to interpretation. And as William will know, being a student lettings person, this is going to be most relevant in the student industry, because most students will get the deposit paid by the bank of mum and dad, I would say, and probably in most occasions, that would probably be the most common way of doing it. Yeah, Gary. Yeah, absolutely. So if the council pay their deposit on their behalf, a physical monetary deposit, because don't forget we're only talking about monetary deposits here, where there's physical money, then yeah, absolutely, Gary, they would be noted as a relevant person, even if they're not interested in receiving the prescribed information which they're entitled to receive. So long as you have something from the council to say, look, we don't want that stuff, then fine, I'm happy with that, and that would be your protection in court. But you just don't know with councils. I mean, I can't imagine a council would try and stitch you up, if that's the right phraseology, but you never know of councils. They're a law unto themselves. A council worker today may not be there today. There might be a completely different person in 6 months' time. So even though they are a relevant person, if they've paid the money on behalf of a tenant, I would still try and give them prescribed information. If they're refusing to receive it, then so long as you've got an email to say that they've refused to receive the prescribed information, then I think you would be protected in any subsequent legal action that was taken by either the tenant or the relevant person, in this case the council. So in my advice to you as agents would be, and landlords, ask the question on the application form, who is a relevant person, as in who has funded the deposit. It's not the responsibility of the tenant to tell you. You've got to ask that question. So ignorance is not a defence. You can't say, well, the tenant never told me. Well, if you never ask them the question, they're not going to know to tell you. So it's your responsibility as the agent to ask that question in the first place. The next bullet point, which we've had an argument about before in court, is it's come from a different person, as in the account payment was made in a different name. So just be wary of that as well, which I fully accept may need someone in accounts to recognise if a payment for a tenancy has come in a different surname. So in this particular argument, they argued that the payment made was in a different surname to the tenant. The judge luckily found in favour of this particular landlord, but you can never tell in court. So just be wary of that. So whoever deals with accounts, if a payment's made, they just need to double check it against the people that are moving into the property. If it's a different surname, then that indicates that it might be a relevant person. But again, it's one of those awkward ones, because I fully appreciate the accounts person probably doesn't want to be dealing with legislation, but that's what I would always do. Just make us aware if there's a different surname to anyone on the applications. That will be one indication that there may be a relevant person. And as always, if they are identified as a relevant person, you must give them prescribed information. So you can just give them a copy of their tenancy and get them to sign it to say they've received it. Don't forget, you need to also include the scheme leaflet. Evidence, as always, evidence, evidence, evidence. As I always say, in terms of civil courts, it's on the balance of probability. Who do they believe? So therefore, evidence is so important in relation to showing deposit compliance from a landlord or letting agent perspective. And the penalty applies. So in addition to the tenant suing you for not giving prescribed information, the relevant person also has the ability to sue you for non-provision of prescribed information. So the penalties can rack up quite severely. You can see how quickly, potentially, it can rack up. So just be wary of that. And relevant person, I would say, is going to be most common in student lets. It's going to be very common in student lets. William, I don't ask you too many questions today, but how many students have a relevant person? It's probably going to be about 1 in 3 at least, I would say. Off the top of my head, I might be completely wrong on that, William. You might say to me, actually, Darryl, it's more than that. Yeah, half of them would have a relevant person, i.e. the banker mum and dad. But even in normal lettings, I would probably say it's somewhere along about 1 in 10 would probably get a deposit paid by someone else, whether it's the local council, whether it's mum and dad, whether it's brother or sister. It is quite a high, potentially a high percentage, depending on who you're dealing with, especially the younger ones. Let's put it that way. I wanted to Yeah, there can be anyone. It can be, yeah. In terms of who a relevant person could be, it could be anyone. It's a tough one, Abby. I think if you ask the question on your application form, that protects you to the majority of the degree. You've asked that question. If it comes from a different person thereafter and you can't check it, then I wouldn't overly worry about it, but I would certainly have a system in place to check account payments just to make sure, okay, there is a different surname, Darryl, on this payment. What do you want to do? Okay, I would then go back to the tenant and say, look, we've got a payment for you in relation to the deposit. It's from Smith and your name's Brown. Who's Smith? They say, oh, my mum and dad are paying it for me. Then I would count them as a relevant person, even if the original application form said they were paying it themselves as a tenant just to protect yourselves. But maybe it's a question you need to ask Good Lord, potentially Abby. I'm not sure if there would be an answer from them on that one, but that's what I would do if I had access to who was making payments. The free schemes and the initial scheme rules. So I fully appreciate I'm going to run over time on this one. So apologies, guys. If you need to go at 12:15, I appreciate that. It will be uploaded to my YouTube channel, but I think I've got another 3 or 4 slides to go. So probably going to be about another 15 to 20 minutes. So apologies. I could talk all day about deposit protection for those that know me. About court cases, the implications. As I said, I see it every day. So I know this is not something to take lightly. It's not like, other things that potentially you sit there and think, okay, yes, the law says this, but potentially for me, deposit protection is one of the biggest issues in relation to being a letting agent or landlord. Hence why, apologies, I'm going to slightly run over in terms of time, but there will be a recording. So there are 3 schemes, as you know, DPS, TDS, and My Deposits. They all offer a version in relation to custodial or insured, which I'm going to assume that you already know in relation to how they work. In relation to the scheme rules, each of them has a different set of rules. So I just wanted to show you where the initial scheme rules are. So don't forget, the initial scheme rules relate to the Housing Act 2004 and the penalty. So understanding the initial scheme rules is so important. So that's why I just wanted to go through each of the scheme rules and just show you where they are, so you can understand what you need to be looking at, because it is quite confusing when you talk about initial scheme rules and scheme rules and trying to understand the difference. So if you just bear with me 2 seconds, I'm just going to try and get up. I just need to. That's not doing it. Oops. Okay. Okay. This is My Deposits. For those that use My Deposits, this is the membership rules for My Deposits. Now, Section C is their initial scheme rules. I don't know if you can read them that clearly. James is having a quick go. Can you read that clearly, James? I don't know how clear that is on your screen, but you can see. Let me just get my. It probably doesn't show my button, or does it? One sec. My drawing tools. It doesn't show it, but you can see. It says clauses C1 and C2 are the initial requirements of the scheme for the purposes of Chapter 4 of the Housing Act 2000. That's basically the Housing Act 2004. These are the requirements imposed by the scheme for a member to comply with when receiving a deposit. So on this particular slide, we have almost, as you can see here, we have almost 2 pages worth up to here, up to basically C 2.4. So for any person that uses My Deposits, you have to read every single clause on that page and a half and make sure you are doing that within 30 days of receiving the deposit. Because if you don't do that, then you fall foul of the legislation. Yes, you might put it into My Deposit scheme. Yes, you might give prescribed information, but if you don't follow every single clause here, C1, C1.2, 1.3, up until C2.24, then potentially that's non-compliant. And if you are non-compliant, you are liable to the penalty. And these are all the things that solicitors will look at when they're dealing with Section 21s and deposit deductions. So that's My Deposits. So I know lots of landlords will use My Deposits, and it's probably it's one of the more complex schemes. So that is My Deposits, and you'll find that on pages pages 12 and 13 of your membership scheme rules, being a My Deposits landlord or My Deposits agent. For those that use the DPS, you might recognize this one if it pops up on your screen. This is the 4 pages of tightly packed writing. You'll find your initial requirements in sections 10 and 11. So actually clause 9 says sections 10 and 11 of these terms and conditions comprise the initial requirements for the purposes of the Housing Act 2004. So for anyone that uses DPS, you've got to make sure, and it's relatively straightforward for DPS, you must make sure that you follow clauses 10 and 11 to the letter. So deposit submission and payment options. So you've got to follow those to the letter. Now, the thing that gets landlords confused, or I would say lots of people might not do right, is the submission to DPS. So when you make the submission, hopefully they will automatically assign it to the right deposit account. What they potentially won't do is if you don't give them the correct numbers, or the amounts being paid are slightly different from what they expect, it will just sit on the overarching deposit account. It won't be allocated to a tenant or a property, and therefore it won't be protected. So if you're allocating large numbers of payments, or you don't give the right reference number, I would always make sure that you go on and you manually allocate it to the correct account. Now, I've seen a couple of people where they forgot to do that, and they only realized after the 30 days, which means they're non-compliant. So if you're using a DPS, even though the initial scheme rules are a lot simpler compared to my deposits, just be wary. I think the manual assignment potentially can be an issue. So that's DPS terms and conditions. It's clauses 10 and 11 of those terms and conditions, which are referred to as the initial scheme rules of the Housing Act 2004. So that's where the penalty applies if you don't follow clauses 10 and 11. So that's the DPS, the Deposit Protection Service. And then you'll be thankful for those that use the TDS. They're a little bit simpler. They've only got four clauses in relation to initial scheme rules, and they are a lot simpler. They basically just say, if you look at 6.2, not 6.2, if you look at 6.3 here, that is basically all they're asking you to do. It just says the scheme's initial requirements are that the member must enter on the TDS database all the required details about a deposit if that deposit has not been previously protected. That's all it really says. Now, the only thing that I don't know, because I've not filled one out for the TDS, is what they require. I'm sure someone will probably tell me, but again, that's all it says. So long as you filled out everything that the TDS requires of you, then that is your compliance with the initial scheme rules. Okay, so the TDS actually are quite good. They don't have very complicated rules at all, very similar to the DPS. For anyone that uses My Deposits, it's a lot more complicated. That's why I generally would not advise a landlord to use My Deposits, because most of them don't do it correctly, from my experience. That's only from my experience. So they are the three sets of scheme rules for TDS, My Deposits, and the DPS. And the reason why I wanted to highlight them is just to make you aware where you can find them. But also, and equally as important, you've got to read them. Are we doing exactly what it requires of us? Because you can put it into a scheme, but if you don't follow the initial scheme rules, you've not complied. And that's the important part to remember. So in addition to that, so let me just go back to my slides. You'll be glad to hear. So that's the reason why it's so important. Initial scheme rules. They are different to scheme rules. Now, a scheme rule might say you must give the deposit protection certificate. Now, if you don't give the deposit protection certificate, which is different to prescribed information, you might be breaking the scheme rules. And the scheme rules might give you a penalty in the sense that they might say, look, because you've not followed the scheme rules, we're not going to adjudicate. Because you're not following the scheme rules, we might ban you from being a member of the TDS, DPS, and My Deposit. So, but that doesn't allow a tenant to get a penalty because they are only scheme rules. The only time that a tenant's entitled to a penalty is if you've not followed the initial scheme rules. I know it's quite confusing. It confuses me, I mean, to be honest, absolutely, and I deal with it all the time. So just to make you aware of that. So if you don't follow the initial scheme rules or give prescribed information to the tenant or any relevant person, you potentially have a financial penalty and a Section 21 restriction. If you don't follow the scheme rules, you aren't going to be penalised under the Housing Act 2004, but you might be penalised by the schemes themselves, if that makes sense. And I know it's one of those really awkward ones where you'll sit there and say, Daryl, why do they make it so ambiguous or so complex? I don't know. I couldn't give you any logical reason as to why they did it. They've made it overly complex, overly legislative for no real good reason. But don't forget, this was brought out by a Labour government, so you can't blame the current government for it, although the current government could change legislation if they wanted to. But I think they're a little bit busy at the moment with parties, etc. We need a good old party. That's what we need. Gaynor, if you had a party, Gaynor, because I think you said I know you had COVID at Christmas and you're going to go a bit of partying in January or February. You told me. So anyway, I don't know. Have you had one? I don't know if you. No, you look okay today, so I don't know if you
No,
had
I
one.
haven't yet. No parties yet.
No parties, no. Okay. Prescribed information. So this is under the Prescribed Information Order 2007. And just to reiterate, this is as important as giving or following the initial scheme rules. So top left, let me get my drawing pen up. Top left, this is a piece of legislation, the Prescribed Information Order 2007. If anyone wants to read it, you can just hit that into Google and you can download it. Basically just goes letter by letter, or Roman numeral, shall I say, what's required. A, you must give the name of the landlord. B, you must give the name of the tenant. C, you must give who's holding the deposit, blah, blah, blah. It goes on for about 15 or 16 requirements. It's not the deposit certificate. So for landlords that use my deposits will produce a deposit certificate which you can then send to the tenant. That is not prescribed information. Lots of landlords assume that is prescribed information. It is not. So therefore, if you give a deposit certificate from my deposits to the tenant, you have not complied. You might have complied with the scheme rules, but you haven't complied with the Prescribed Information Order 2007. That is probably one of the most common misunderstandings by landlords in particular who use my deposits. Because I go to them, can you provide me a copy of the prescribed information that you've given? And they will always give to me a copy of the deposit certificate, which is different to the prescribed information. So for any landlords that use that, just be aware of that. That's really important to understand. Just to reiterate, it's the information that's prescribed, not how it looks. So in theory, you could write it on the back of a fag packet, or in my case, in section 8 of my tenancy agreement. And that is sufficient enough for compliance with the Prescribed Information Order 2007. But obviously, in addition to that, as I always reconfirm, you've got to give the scheme leaflet as well, because I don't provide the scheme leaflet in the tenancy. So therefore, you've got to download it off the relevant deposit scheme website and make sure that you give the scheme leaflet to the tenant. We've had a court case on it already, just to make you aware. You cannot send them a link to the scheme website and the scheme leaflet. You must physically give it to them. You can give it to them in physical terms, or you can give it to them by an email with a scheme leaflet attached. But what you can't do is give them a link to the scheme leaflet, which I know sounds crazy, but we've had that court case already, and that's what the judge said. Okay, very clearly. So if you did that, you would be deemed to be non-compliant. 100% of the prescribed information is required. So missing bits off is not compliant, or I would argue is not 100% compliant. So for example, where I ask about a post contact address, you can't leave it blank. Now, I know lots of people will leave it blank because a tenant won't tell them a post contact address, but you should have something written in there in some form. So even if the tenant's refusing to give you a post contact address, put that in there. But tenant has refused by email to give me a post contact address. That's fine, that's covering your own back. What you shouldn't do is leave it blank or put not applicable, because it will always be applicable. The post contact address is all about where can the schemes contact the tenant at the end of the tenancy when you're dealing with deposit returns. So there should be an address of some description in there. It can be any address. I don't care where it is in the world. I don't care whose address it is. Just always put the address in there. So that's really important. All the information should be in there. I think does it ask for a fax? I think it asks for a fax number from memory. So again, fax number, I would certainly put not applicable in that case, because most people won't have a fax number in 2022, but I think it still asks for a fax number. As I say, in my agreement, for those that use MPO, any MPO members here, if you're using the MPO agreement, then it will be contained within section 8 of the tenancy agreement. Just need to reiterate again that the scheme leaflet is in addition to that, so you need to give the scheme leaflet. As I said, really important, if each of the schemes provide you a template. So My Deposits, DPS and TDS will provide you a template to complete the prescribed information. What they won't do, sometimes they will partly fill it in for you from the information that you've given, but what they won't know obviously, is the reasons for which you can deduct from the deposit. So I will see quite a lot of templates provided for by the schemes which landlords have filled out or agents have filled out, but what they haven't filled out, obviously, is the reasons for which the deposit can be deducted. Now, in my version of the agreement, it will see, please see section 2, tenants obligations, because that's what my tenancy agreement says. However, the schemes can't do that because they don't know what your agreements will say. They don't know what section the tenant obligations will be in. So if you're a landlord or a letting agent using the templates for prescribed information provided for by the schemes, you've just got to make sure that you fill in this section which says what are the reasons for which the deposit can be deducted. Now, I see lots of them just that are blank. They don't say anything at all. Well, if they're blank, very clearly the tenant's going to say to you, well, you can't deduct from my deposit because you've not said anything about it in the prescribed information. That would be the logical conclusion. So from my perspective, if you are using the templates provided for by the schemes, you've just got to make sure that you fill in the relevant section which talks about what are the reasons for which the deposit can be deducted, because leaving it blank will lead, or I would say result in you not being able to make any deductions from the deposit whatsoever. And I think what Anya mentioned, and we'll talk about it later, very quickly, about signed correctly. So the landlord does need to sign it. In addition to that, if they are a limited company, at the moment, I would always argue that they sign it in accordance with the Companies Act 2004. I laugh at that because that was the big court case this week. But signed correctly, absolutely, it does need to be signed. What you don't need to have is the tenant signature. It says you must give the tenant the opportunity to sign it. Now, if they don't sign it, that's fine. You don't need to go run after them to get them to get it signed. Mind my language today. So that's fine. So long as you've given them the opportunity to sign it. And that's why it's very good to have it in the tenancy agreement, because they will always sign the tenancy agreement. So they will always sign the prescribed information by default. Next slide, because I appreciate we're in terms of times. Yeah, I don't want to go through this too much, but for those that are set up as a limited company, as of today, as of the 21st of January 2022, if you're a limited company, you must sign it to be belt and braces in accordance with the Companies Act 2004. And I will always say it again, 2 directors or 1 director and a witness. Until we're told differently, that is the belt and braces way of doing it. If you're set up as a limited company, as an agent or a landlord, and you're signing prescribed information on behalf of yourself or your landlord client, always sign it. 2 directors, 1 director with a witness. If you're sending it electronically, the electronic signature is not a witness, in my humble opinion. So you would always still need at least 1 director and 1 witness. So that's the way I would do it, to be 100% belt and braces. For anyone that was as sad as me listening to the court case for 5 hours on Tuesday, which did bore me ridges, to be fair, you will understand the length that people will go to in relation to defending Section 21 notices and deposit compliance. So from my perspective, that's the belt and braces way of doing it. I know most of you will be set up as a limited company. And I've mentioned this numerous times, so I don't want to keep going over it over and over again, but it's so important. I can't understate the importance of following those rules if you are trading as a limited company. And the last slide, you'll be glad to hear. And again, as you probably all know, I've got a webinar on this. So if you look on my YouTube channel, there is a webinar detailing what you need to do with changes of tenant. So I don't want to go too much into this, because again, you can watch another webinar which will explain in a bit more detail what you need to deal with when you're doing changes of tenant. But as you probably know, we've had a recent court case which very clearly defined what happens at changes of tenant. And from my perspective, it's a brand new tenancy. So wherever you're making any changes to the tenants, whether you're adding them, replacing them, or deducting them from a tenancy, always deal with it as if they were moving out and moving in again. Now, physically, they may not be doing that. I fully accept that. But in legal terms, they are. So you end one tenancy, and then you start basically the whole process. So I end the tenancy, as in end the deposit protection. I deal with any deductions, if that's what you want to deal with. I deal with any replenishing of the deposit, and then I re-protect the deposit in its entirety again for the brand new tenancy. Now, as I said, there may not be there may not be a physical move out of everyone. There may be a change of a joint tenant. There may be one tenant being replaced. There may be one tenant being removed. I don't know. But if there's any changes of the tenant, the belt and braces way of doing it is treating it as if they've all moved out and a brand new set of tenants have all moved in again. Now, physically, they're not doing that, but in legal terms, they are. So therefore, you end the deposit protection for one tenancy and you create a brand new deposit protection, reserve prescribed information, all those things as well again, and that will be your belt and braces way of doing it. For those that remember, there was a big court case on it recently, which very clearly defined what a landlord should be doing. And you'll find that in relation to, on my YouTube channel, you'll find another webinar, which is about an hour long, which talks about changes of joint tenants and all the things that you need to be doing when you're dealing with changes, replacements, or even removal of a particular tenant off a tenancy agreement. Because in that sense, the reason why it went to court is because the tenants were trying to sue the landlord for deposit compliance and a financial penalty. You'll be glad to hear, last slide. As I said, I could run a whole day course. I do run the whole day course, shall I say, on deposit protection because it's so complex. You might say to me, Daryl, in 15 years, I've never had a problem. That's fine. And I will always say the words yet. And that's all I'm trying to say is I see it so many times, especially with landlords, self-managing landlords, they get it wrong a lot of the time. And I don't want you to be in court. As much as I love test cases and I love seeing test cases, I don't want you being one of my clients to be a test case because it's very expensive and it makes me look really bad as well, obviously. So from my perspective, it's just really important for you to understand what you need to do in terms of deposit compliance. So important to understand. Hopefully this webinar has helped in some element of understanding deposit compliance. Where unsure, go beyond what you need to do. I think Claire mentioned earlier, if we're going to serve a section 21 and we're not sure what we've done previously, serve it all again, serve everything again. You can never serve too much, and I will always say that in my courses. Just bombard the tenant with lots of stuff because they will get confused, which is a good thing. Non-compliance, as a general rule, if you've not done it correctly and there's a deposit deduction to be made, as you probably all know, don't make that deposit deduction. If it's 500 quid and you know you've not done it properly, as in compliance, why even chase the 500 pounds? Because as soon as you chase that 500 pounds, that's when the tenant goes and seeks legal advice. That's when they go, oh, Daryl, by the way, can you have a look at my paperwork? Because my landlord's trying, or my agent's trying to deduct 500 pounds from my deposit. And the first thing I will go to is your deposit compliance. Do we have any leverage as the tenant to try and push back on this 500 pounds? Well, actually, the tenant doesn't owe you 500 pounds, Mr. Landlord. You actually owe them 2,000 pounds because you've not done deposit protection correctly. So if you know you haven't done it correctly, personally, I would try and mitigate that risk by not deducting or whatever it's going to be. As you may be aware, in terms of civil claims, there's a maximum period of 6 years. So if you protected the deposit in 2015 for argument's sake, and the tenancy hasn't been renewed since that date, but you did deposit protection incorrectly in 2015, the tenants can't sue you for compensation because civil claims have a maximum of 6 years. They call it statute barred for anyone that's heard it before. Personal injury, it's 3 years. But in civil claims and most other things, it's 6 years. So if you didn't protect the deposit correctly in 2015 and you wanted to serve a Section 21 today, you still need to comply in relation to giving the deposit back to the tenant to serve a Section 21. But what the tenant couldn't do is then sue you for non-compliance because your non-compliance was in 2015, which is over 6 years ago. If you renew the tenancy every year and you haven't complied, obviously it reignites the ability for them to sue you. So if I protected it in 2015 incorrectly and I renewed the tenancy every year thereafter, the tenant can't sue me for the non-compliance in 2015, but they potentially could sue me for the non-compliance in 2017, 2018, 2019, 2020, blah, 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 and ongoing. So the 6-year bar goes back obviously 6 years until such a stage that if you renewed the tenancy after and you still hadn't complied, it may reignite the ability of the tenant to sue you. And the last bullet point, which I know no one ever listens to me on this one because no one's done it, but I personally would never take a deposit. And I know that's really easy for me to say. If I was a landlord today and I wanted to take I would not take a deposit. I would just advertise my property at £10 more a week or £25 more a month. I would just say it's 1,025, no deposit. That's how I would do it. Personally, but I fully accept that's not always easy to do, especially if you've got a property that may be hard to let. I don't know, but I think the reason why people take a deposit is to protect themselves against damage or rent arrears, whatever it's going to be. But if the tenant's going to cause 10 grand's worth of rent arrears, what's a deposit really going to do? Not a lot. So I personally wouldn't do it, but I fully accept there are pros and cons to that. But if I was starting it again as a letting agent or landlord, I would definitely not take a deposit, which would sort of make me redundant in terms of compliance. But that's what I would do to reduce my risk as a landlord or letting agent. You'll be glad to hear, way over time, obviously. What time is it now? Yeah, nearly 15 minutes or 25 minutes over time, is it? Yeah, 25 minutes over time. So apologies, guys. Any questions? No. Well, let's hope we win on Sunday, James. I'll take a draw. I think the draw would be good. I'll take a draw. Any questions? No, apart from Darrow, it's 12:40 and we want some lunch. No, that's fine. Okay, I'll stick the recording on the YouTube channel. Hopefully most of you got the link to the YouTube channel. If you haven't, then ask me and I'll send it to you. But all my videos go up there. I take them off again if they go out of date. So I've done quite a lot of videos, but a lot of them have been taken off, obviously, because they are no longer valid for the purposes of legislation. So they will change. But I'll put that on my YouTube channel, and if you need to watch it again, you're more than welcome to, obviously. But I wish you all well, because I don't think there were any questions apart from have a great weekend. Oh, do you have a link to each of the leaflets? I think you asked me that. Did I not send you the mod? I don't. I'll try and send them to you, James. They're not that hard to find. So maybe when you're watching the Tottenham Chelsea game, you can search on Google for them. But I'll try and send them to you anyway. No problem at all. Any other questions? No, I'll leave you all in peace. Failing which, thank you guys. Bye, Claire. Bye, guys.